Voilà, colleagues, mesdames et messieurs, mesdames et messieurs les membres de la commission, mais aussi bienvenue aux non-membres de la commission. It is with great pleasure that I open our parliamentary seminar on the European Court of Human Rights, the way forward, achievement and challenges. I would like to begin by thanking our distinguished speakers for accepting the invitation of the committee to participate to this seminar. First of all, Professor Marc Bossuit from the University of Anvers in Belgium, who is former president of the Belgium Constitutional Court. Also, Professor Grzysztof Drzewicki, sorry for the pronunciation, Drzewicki, of the University of Gdańsk, and he's also a former agent of the government of Poland before the European Court of Human Rights. Also, we have the honor and pleasure to have with us this afternoon Dr. Peter Stederhan, who is a German senior prosecutor and a member of the Bureau of the European Association of Judges. The European Court of Human Rights is sometimes described as the jewel of the crown of the Council of Europe. 67 years after it was adopted, it continues to provide the foundation of our organization's pan-European human rights protection system and a basic reference for domestic legal system in all our member states. During this time, the court has had to overcome many challenges and has gone through a series of reforms in a process that has been almost constant in the last 20 years. Many of these reforms were directed at its caseload, which 5 years ago had reached alarming proportion. Some 90% of those cases were clearly inadmissible. However, and thanks to its reform, the court is now much better equipped to deal with this problem more quickly and more efficiently. Progress is also being made with repetitive cases arising from systematic and structural problems in member states, although with frustrating slowness on account of certain state failure to resolve long-standing issues. Other problems have been even less easy to contain, let alone to resolve. This includes almost 21,000, I repeat, 21,000 pending cases at the end of last year that were neither inadmissible nor repetitive, and so require detailed judicial examination. Such a large caseload is a matter of concern, even if it is largely beyond the court's control. Last year only, the court received some 53,000 applications, a 32% increase on the year before. Caseload issues have not, however, been the only challenges faced by the court. Academics, judges and politicians has criticized its application of the principle of subsidiarity, including sometimes the jurisprudence, and the way in which the court affords a margin of appreciation to national authorities. This has been an area of particular sensitivity for some states in areas touching on core issues of national sovereignty, like border control, immigration, family reunification, terrorism, and so on. They are also of particular interest for many of us, and I have asked our speaker to consider addressing them in their presentation. Colleagues, tens of thousands of desperate individuals have found justice in Strasbourg, sometimes for violation committed in situations of armed conflict and massive human rights breaches. As recently as last year, the court found 24 cases of violation involving unlawful killings. We should be happy that the court contribute and also has been instrumental, in fact, in protecting the rights of individuals, vulnerable groups, and minorities. My last remarks before giving the floor to our invited speakers, it was always my intention that this seminar be followed by other events to continue the discussion. So I think after hearing the three experts today, in the next session, maybe in October in Strasbourg, I believe it is also important that we also hear from the court itself and about the recent achievement and the challenges it faces. So I therefore propose you, dear colleague, to organize a further seminar in October, for example, to which we can invite the court as such to present the challenge for the future of the court. So thank you very much for your attention, and I give immediately the floor to Mr. Professor Bossuit. You have the floor for 10-20 minutes as agreed.
Merci beaucoup, Monsieur le Président. Monsieur le Président, mon sujet que j'ai intitulé « La Cour de Strasbourg des juges sans frontières » parce que je crois qu'il y a un problème dans la mesure où la Cour ne sait pas très bien où il faut fixer les frontières de sa juridiction. Dans un livre relatif à des arrêts en matière d'asile, publié en 2010, j'écrivais que les arrêts de la Cour de Strasbourg sont généralement accueillis avec enthousiasme par les avocats, avec ferveur par les chercheurs scientifiques, avec complaisance par les journalistes, avec soumission par les juges nationaux et avec résignation par les hommes politiques. Et j'écrivais également qu'au nom de l'interprétation dynamique et téléologique, la Cour s'avance progressivement sur la route d'une juridisation toujours plus grande de la société européenne, sans trop se soucier de ce qu'ont voulu les États en devenant partie à la Convention. Toutefois, je me suis aventuré à critiquer la jurisprudence de la Cour dans la conviction qu'une analyse critique de la jurisprudence a des effets salutaires sur son développement. Mais les risques d'une telle entreprise sont grands. Je peux me référer à ce qu'a écrit l'ancien juge britannique Paul Mahoney dans le préface d'un autre livre, et je cite, et je continuerai désormais en anglais, « Those who dare to criticize the court are regarded almost as renegades or traitors. They are not true human rights patriots." In my present intervention, I will direct my criticism mainly to A, the attribution of positive obligation to civil rights, and second, to the case law concerning asylum seekers. Already from 1968 on, the court has attributed positive obligations to rights and freedoms set forth in the Convention. And later, mainly based on the protection of property, the court extended its jurisdiction to social rights. Many of those extensions are based on famous dicta of the court that the Convention is a living instrument which must be interpreted in the light of the present-day conditions, and that the Convention is intended to guarantee not rights that are theoretical or illusory, but rights that are practical and effective. Personally, I believe that the court exceeds the limits of its jurisdiction when it transforms civil rights into social rights. And this happens when the positive obligations attributed to civil rights cannot be afforded by all states and require choices to be made and priorities to be established at the expense of other rights or other categories of persons. In my view, some aspects of the creation of new positive obligations are problematic. A, because I believe that in conformity with the separation of powers principle, it's up to political organs to create new rules, and it's up to the court to interpret them. B, an international court composed overwhelmingly by non-nationals non-nationals should, in the absence of legislative checks and balances, exercise its jurisdiction with even greater restraint than domestic judges. See, in matters of economic and social rights, there are no universal human rights standards, but at best only regional standards, unattainable by many countries. The concomitant enlargement of the jurisdictional control of the prohibition of discrimination amounts to relinquishing a greater degree of sovereignty from the national legislator to the international judge than is the case with civil rights. And finally, the reliance of the court on EU law to define the extent of positive obligations is highly questionable in my view, because the court may not, I believe, interpret the regulations and directives with respect to the 19 states parties to the European Convention which are not members of the European Union. And the court may not interpret the extent of the obligations applicable to the 28 member states of the European Union differently from those applicable to the 19 other state parties to the Convention. And finally, it's not up to the Court of Strasbourg, but to the Court of Justice in Luxembourg to interpret the extent of the EU regulations. I refer also to Baroness Hale of Richmond of the Supreme Court of the United Kingdom, who in speeches delivered in 2011 said, well, there should be some limits to the jurisdiction of the court. Unfortunately, the court appears to accept only self-imposed limitations to its jurisdiction. And I quote what I have written before, since treaties are only binding because, and to the extent that states have expressed their will to be bound by them, international judicial organs, even more than national judicial organs, should exercise their competence with caution and circumspection, with restraint and reservation, and to disregard willingly and knowingly the intentions of the authors of a treaty amounts to a limitation of state sovereignty without democratic legitimacy. Second part of my intervention is the case law of the court concerning asylum seekers. Most judgments concerning asylum seekers have two specific characteristics. First, the violations found are indirect, because the state parties are held responsible for actions committed by other states, very often non-state parties to the Convention. And second, those violations are potential, since in most of the cases, the prohibited acts have not yet taken place, but could take place if a foreigner is compelled to leave the territory of the state party. So instead of evaluating facts that did happen in state parties to the Convention, the court speculates about events that could happen in non-state parties to the Convention. I'd like to refer also to the judgment Mamadkulov and Askarov of 2005, in which the court decided that its interim measures had become binding. Since then, we have seen an increase of those applications for interim measures from 112 in 2006 to more than 4,000 in 2010. And even more, before that judgment, between 1991 and 2005, the court found only 4 indirect violations of Article 3 of the Convention. Since that judgment, the court already found more than 126 such violations. I will now refer to 2 judgments of the court in matters of asylum, MSS and Hirsi-Yama. In MSS versus Belgium and Greece of 2011, the Grand Chamber considered unacceptable the conditions of detention, the living conditions of an asylum seeker after his transferal by Belgium to Greece under the Dublin regulation. And Greece was condemned to pay 1,000 euros because it was directly responsible, and Belgium was condemned to pay 24,000 euros for an indirect violation of the same article. There are also other developments in these judgments which, in my view, raise concern. It's A, the lowering of the threshold of Article 3. It's B, the expansion of the list of particularly vulnerable groups. Also, asylum seekers, a self-elected category. And C, the extension of the applicability of Article 3 to the living conditions of asylum seekers, transforming thus a civil right into a social right. Despite that judgment, which seriously undermined the Dublin regulation, now, more than 6 years later, the situation in Greece did not yet improve to the point that transferal of asylum seekers to that country is allowed for. And if it is considered that it is the application of the Dublin regulation that led to unacceptable conditions for asylum seekers in Greece, well, the asylum crisis in the Mediterranean showed that its non-application led to unacceptable conditions on the Western Balkan route in several of the state parties concerned by that route. And finally, it brought the Schengen system to near collapse. The second judgment I want to mention is Hirsi-Yama versus Italy of 2002. And in that judgment, the Grand Chamber found an indirect violation of Article 3 of the Convention by Italy, and it awarded 15,000 euros in its to 11 Eritreans and 13 Somalis who had tried to reach Lampedusa by boat and were sent back to Italy by the Italian Coast Guard. As a consequence, the maritime external borders of all member states of the Council of Europe are wide open for anyone applying for asylum, even on the high sea. And it did not tend to discourage migrants to undertake a perilous journey at the risks of their life, nor did it contribute to diminish the number of persons drowned in the Mediterranean. Finally, I refer to a more recent judgment, FG versus Sweden of 2016, in which the court became more and more demanding as far as the asylum procedure is concerned. It has even a whole number of paragraphs under the subheading, the procedural duties and the examination of application for asylum. And another Grand Chamber judgment of 2016, Papelsvili versus Belgium, the court recommended the establishment of appropriate procedures to verify whether the medical care available in countries of origin of aliens residing irregularly in state parties to the Convention, whether this is sufficient and appropriate. So I note that despite the absence of any right to asylum in the Convention, the court acts as if it were a legislature competent to determine as well an asylum procedure as a medical asylum procedure in the 47 member states of the country of Europe. Because even when the asylum seeker has not invoked Article 3 of the Convention before the national authorities, they have to examine a possible violation of that article of their own motion. And in doing so, I believe that the court behaves as a self-appointed asylum court. Despite its own denials, the court frequently acts as a court of fourth instance. This is the case when the court substitutes its own appreciation to that of the specialized national authorities. And when it takes into account new elements, which have not been brought before those national authorities, it even acts as the first instance, without giving the national authorities the opportunity to examine those elements and without having their level of specialization. So in conclusion, Mr. Chairman, I will quote something I wrote in my book of last year, that there is a tendency nowadays of systematically favoring interpretations benefiting to the applicants while overlooking too easily the far-reaching implications those judgments may have for the society as a whole. And by continuously tilting the balance in favor of individual applicants, without taking fully into account the difficulties democratic governments experience in coping with the challenges of our present times, it divorces human rights protection too much from the pressing needs of the realities of today's world. I thank you for your attention.
Thank you very much, Mark, for this very strong statement. I'm sure it will bring a lot of questions and comments. This is not the kind of language we hear that often in this assembly, but we are for free speech and democratic debate, and of course all views could be challenged. And I'm also looking forward to the kind of response that the European Court of Human Rights can bring to your statement. But in the meantime, I will give the floor now to Professor Christophe Jericki from the University of Gdańsk. Professor.
Thank you very much, Mr. Chairman. My name is easier than you think, Christophe Jericki.
Yes, very easy, sorry.
I understand your difficulties as we have those with Russian or Chinese names. I would like, first of all, to appreciate very much this invitation to the panel discussion. Particularly, I was invited to take a position of those to criticize the whole system, along with my distinguished colleague, Professor Bossaut. But I was struck by your committee's report, Rapporteur Pierre-Yves Le Borgny, where in the draft resolution, this is document of June this month then, when there is a proposal and a recommendation to address to government, to state parties, among others, para 9.6, to condemn any kind of political statement aimed at discrediting the court's authority. I understand that this is taken seriously in proportion to free speech, and this, my colleague, my predecessor, and mine criticism of the court here will not amount to this step of this provision. I hope this is not a problem. Ladies and gentlemen, distinguished members of this committee, I would like, having seen this imbalance between two of us, to be more critical, and only one member of the panel who was asked to defend the court. I would like to restore this sort of lack of equality of arms, and first start with a few compliments and then to criticize. Without criticism, the court would not be like it is today. No doubt, the European Convention and the whole system is an uncontested success in modern international relations. This is the most, indeed, the most sophisticated system for the protection and promotion of human rights in the world. That is true. It is, as some people say with exaggeration, perhaps the pearl in the crown of the Council of Europe. It is a model followed inefficiently, in my view, by other regions. Look what other regions are doing, and less effectively as our system. So it is, for me, also one excellent lesson. European Convention system is the best proof that human rights need to be taken together with democracy and rule of law. Otherwise, we achieve very crippled results. This must go together, compared in any studies, UN or other systems deprived of that whole background. So having these compliments in mind, I would address few critical issues which I called failures and disappointments, and starting with this criticism that often is used in UN, in the Council of Europe documents, that the European Convention is a victim of its own success, a sort of propagandistic statement. And it's true, but with a proviso. Let's add also that the European Convention is also a victim of its own failure. Failure, for instance, to deal with human rights in reasonable time. So that's, for instance, one thing. Let's be fair to the court. Let's be fair in proportion to its both successes and also failures. As for failures, I would like to start from something that comes to me as an Eastern European. Namely, I think that this excellent effort the Council of Europe did in the so-called within the so-called Ostpolitik by Madame Lalinière in '88 report here in the Assembly, that all these efforts, obviously, as we expected, did not sufficiently advance the whole transformation of Central and Eastern European countries to European standards. It needs decades. But nevertheless, within this whole move in 89-90 to as quickly as possible admit new members, what they call new democracies, although among them there are quite old democracies, like Poland, Hungary, Czechoslovakia. So there were few candidates in the 1990s which in fact should have been barred from entering this organization. Their admissions were premature, overly motivated by political considerations more than by legal appraisal, particularly through the rule of law. So we accept this and congratulate the Council of Europe for this excellent effort, but we should see how much certain decisions were premature, and results of that we have today, like in the Assembly, questions concerning few countries. We must also say, it is not a criticism, it's a statement of fact, that certain measures adopted against our countries, I say against in terms of judgments versus somebody, made in midterm very much heavy burden on newly admitted states by requiring them to substantially reform, and in a quite short time, judicial, prosecutorial, and penitentiary systems. You know what happened in a very nutshell? Article 6, for instance, fair trial. We had some courts under communist regime, but what happened, they started to be genuine courts. They got more competence, and Article 6 guarantees were extended to pre-trial proceedings or stages and post-trial, penitentiary and others, enforcement. So suddenly courts, in fact, got some, people say 30 to 35% more of competence, more of powers to exercise on that time. But we have had, and we are trying to swallow this and to digest it, which is most important. I would like also to say that we are perfectly aware that one of the requirements for admission, which is that a country must be not only, let me remind, democratic country, rule of law country, human rights country, country with European vocation, but be also peaceful country. Read this through preamble to the statute. It must be peaceful country. So we should rather try to not to seek UN type of criteria, which is called peace-loving countries, but genuine, we should be members who are living in peace and not interfering in peace with others. So this is clear how much we live in this framework, in this environment, which we accept, of course. Next point, development of case law of the European Court shows, in my view, in many instances, a leaning to the role of human rights activists instead of human rights judicial protector. Human rights are a very typical sensitive area which are under pressure of human beings, of human rights holders, of the civil society at large. But should the court all the time try to be more inclined, I see my predecessor has expressed similar views, towards the applicants. In some groups of cases, it is perceptible that in a struggle between what we call to our students judicial constraint or judicial activism, unfortunately the latter often prevails in the case law of Strasbourg Court. This is notably discernible, let me give you just an example, in such areas as the right to respect for private and family life under Article 8 of the Convention. For instance, that's interesting phenomenon for researchers. Stronger protection of the right to life under Article 2, stronger in terms of legal formulation, becomes gradually replaced by and through Article 8 or 10. See pretty case. So these hardly protected values go through more qualified Articles 8 and 10. One commentator noted that Article 8 opened, in fact, the door to, quote, paradise of claims. And he's rightly saying so, making it possible what is impossible under Article 2 and 3, because they have more absolute character. To protect copyright of my colleague, this is Professor Jasudowicz from Poland, submission. Next point which I would like to make is the question of evolution of the case law, which touches the question of the right to maintain and preserve deeply rooted societal notion of family as a union of men and women. This is what I speak myself because I quote and believe in Article 18 of the Polish Constitution. But if other countries wish to go further, let them go. But why the court is trying, in this or other elements, to impose this trend on other countries? So the wisdom which we expect from the court should be to respect pluralism and not symptoms of what is called urawniłowka in Russian. That is the Russian term for imposed and artificial equalization of all human beings. I hope my colleague Igor Boris will agree with my definition of urawniłowka. There is also yet one comment about these extensive interpretations, namely, while referring to the concept of living instrument, already mentioned here, living convention as a living instrument, crowds of lectures we are giving to young public is enchanted by living instrument. But there is a lot of buts. The court should not be by this encouraged to use it as a basis for its law-making endeavors. That is so. Mark's case, professor of your country, due to some resistance of Belgium to change legislation of children on protection of children in succession proceedings, children born out of wedlock. It was too long, but it was not necessary to call it living instrument. Just it was used through non-discrimination rule and other arguments. Okay. So I agree that here the court should be fair in moving between living instrument concept and attempts at unfortunate attempts at law making. Further, European Court should not overlook the principle of subsidiarity. Although the court often quotes formula that these are domestic courts and other bodies which are closer to circumstances of the case, but in fact tries often to replace their perception by its own view. This is clearly in matters concerning questions concerning margin of appreciation, which is important issue in cases concerning fight against terrorism, immigration, border control, and family reunification. Here, respect for variety, diversity of national cultures and legal arrangements should be broader. We do not like, at least myself, extensions made with regard to Article 41 on just satisfaction. First, just satisfaction, French, dommage moral. Since long time it is no more just satisfaction. It has gone towards regular compensation proceedings. Luckily, up to now, if I follow well, mainly limiting to damnum emergens and not going to fructum cessans. This would be a further tragedy in extension of rules.
I think you have to conclude, please.
Allow me, yes, to conclude. I'm also voicing very important argument, I believe, that certain legal cultures should not have been subject to imposition of certain rules. For instance, Hearst case versus United Kingdom, against which I'm very strongly, because blank prohibition of participation by convicted prisoners in electoral, in election, local elections and parliamentary election is done fairly by law of the country, and it was legitimized largely. Why Europeans had to impose this, their own individual system, that each judgment should decide about civic rights? This is something I disagree, because they have a right to do so. It's fair, democratic, and protecting society from criminals. One of my, from the section of, I would in 1 minute, of challenges, Mr. Chairman, I would like to point to alarm, at least with one recent, since 2-3 years, development in the Council of Europe and the jurisprudence of the court. Namely, we should be very much worried, more than we are in the Venice Commission and in the Assembly, with amendments to the Constitutional Court Act by Russia in 2015, whereby, as you may know, Constitutional Court has been empowered to determine whether judgment of the European Court is compatible with the Russian Constitution. Of course, go to Article 26 and 27 of the Vienna Convention on the Law of Treaties, and then you would read where is the problem on the Russian side, because they should have complied either before admission to the Council of Europe or do not allow this situation to arise. I have also a few other remarks, but I would limit myself to those concerning certain general precaution.
Can I
one
propose
sentence?
that? Yeah.
Yeah?
But you have an opportunity to respond there.
Yes, I will come back to the others. Perhaps I will be very strong in this formulation. If the court would not be more balanced in its case law, we are sometimes afraid, sorry for strong words, that this is not a good contribution to Rechtsstaat, but to what the Germans call Richterstaat, in a pejorative sense of rule of judges, not rule of law. Thank you.
Thank you very much, Professor. We're going immediately to hear to Dr. Peter Schneiderman. So he's a senior prosecutor, member of the Bureau of the German Association of Judges and of the European Association of Judges. Professor.
Dear Mr. Chairman, dear distinguished members of the committee, thank you very much to give me the opportunity to give some short remarks on the European Court of Human Rights from the view of a practitioner. Of course, as a prosecutor in Germany, I'm sometimes not very happy about some decisions of the court. It would be funny if it would be otherwise, because it is the task of the court to decide, and sometimes the outcome is such as you don't like it very much. However, as a member of the European Judges Association, I can argue the other way around, and having, say, as a member of the German National Authority, Germany having lost cases which is causing us problems, as a member of the European Judges Associations, there are cases in which I would like to have the court get into. And at the moment it is the situation with our Turkish colleagues and the situation that the court is not taking up their cases under Article 35, subsection 1 of the Convention, and arguing that there are national remedies beforehand. This comes to the question about the concept of subsidiarity and the question how this can be used in shaping the decisions of the court and in seeing how the court can work more effective. I think the concept of subsidiarity in itself is much too vague a concept for distributing in a clear way the power between a national and a European institution. It does not tell when a decision has to be made on a national level and when it has to be made on a European level. However, the court has started before Protocol 15 was being drafted to work out some ideas about some concepts about how to use the concept of subsidiarity and the margin of appreciation to distribute the decisions between the national authorities and itself. And this shows that subsidiarity imposes a burden on the national authorities and not only on the Court of Human Rights to restrain its jurisdiction. If you look at some of the concepts, like that the court imposes duties on fact-finding on national courts as part of the concept of subsidiarity, and if the national authorities, the court fails in it, it steps in. If violations of the convention are being argued before national courts, it is up to the national court to argue with rigor and care why this did not happen. And if a national court fails in doing so, it is for the European Court of Human Rights to intervene. Or, taking up the political side, if an extensive parliamentary debate has taken place and the arguments on the national level has to be weighed pro and co in a very careful way, then it is up to the court to accept this result as something of cultural identity. So the concept of subsidiarity does impose on the national level quite a duty to act in a very, very careful way to deal with questions of freedom and rights under the convention very, very effectively. And if this does not happen, then it is up to the court to step in and to intervene. I think the protocol, Article 1 of the protocol number 15, that shows this in a very clear way, that it is up to the national authorities, to the high contracting parties, to secure the rights and freedoms of the citizens. And in doing so, they enjoy a margin of appreciation, but they must handle this very careful, and it must be subject to the supervisory jurisdiction of the European Court. So it's up to the court to decide at the very end if an infringement of the convention has taken place or not. It cannot be left to the national authorities. But first and all, it is to the national authorities to do this and to see if an infringement has taken place, and to avoid infringement by drafting carefully legislation. And especially, and with this I come to what I think is one of the ways forward, to enable national jurisdictions to do their job properly. This means that high contracting parties, that member states of the convention have a duty under the convention to secure a truly independent and well-equipped judiciary within their countries, judges which are being able to take up the cases being brought to them and in which a breach of the convention is being argued, so that these courts have the opportunity and the time to take proper evidence, to argue a case in full merits, and then to decide. And my feeling is if this is happening, then the court in Strasbourg is much more reluctant to step in and to intervene. And if this is not happening, if a rash political decision has been made without a broad debate, or if cases are being rushed through courts because judges are being overloaded with work, or even maybe if there is pressure on judges which don't allow them to decide independent and on the merits of the case, then it is much more frequent that the court intervenes. Of course, this does not stop the court to decide sometimes against high contracting parties in a way which they don't like. But all contracting parties have signed up to the treaty, and I think the treaty is not a dead instrument being written sometimes in the last century. But of course it is a living instrument which has to adapt to the needs of the people of today. 53,000 applications this year show that there is a need for the court to decide on cases of everyday life and not on the life in the middle of the last century. So the court has to adapt its jurisprudence on the everyday cases being brought before it. But to live fully on subsidiarity and allow member states, high contracting parties, the margin of appreciation, they really should do what they can in ensuring that their national jurisdiction is able to work and to do the job and to try and avoid cases being brought to Strasbourg. Thank you very much.
Thank you very much. Merci beaucoup. I'm sure this will bring very strong questions and comments. If you wish, I would like first to give the floor to Mr. Le Borgne, because he was mentioned by Professor Jaworski. I don't know if you wish to be the first speaker.
Merci, Monsieur le Président, pour votre généreuse offre de me donner la parole en premier. Je suis ravi, en effet, de pouvoir poser une question et éventuellement de pouvoir apporter la contradiction, parce que je n'ai pas beaucoup entendu de contradiction dans l'ensemble des prestations à ce jour, à cette tribune. Je dois vous dire que je suis troublé par le fait que dans cette semaine où je présente le 9e rapport sur l'exécution des arrêts de la Cour, l'exercice de ce mardi m'apparaisse est une attaque à charge contre la Cour. Et je regrette qu'il n'y ait pas davantage d'échanges, pas simplement entre nous et les panélistes, mais entre les panélistes eux-mêmes. Mon rapport, apparemment, et les conclusions, ou en tous les cas, l'une d'entre elles, ont été mises en cause. Je voudrais simplement rappeler que nous sommes ici des élus et des parlementaires qui ne sont pas illégitimes en vertu d'une élection à débattre à la fois de l'existence de la Convention européenne des droits de l'homme et de l'exercice de son contrôle par une cour située de l'autre côté du canal, ici. Et figurez-vous qu'il y a parmi nous, aussi surprenant que ça puisse peut-être paraître à certaines oreilles, des spécialistes aussi de la jurisprudence de la Cour européenne des droits de l'homme. Donc nous ne sommes pas non plus illégitimes pour en parler au-delà de notre élection, parce que nous avons pu étudier, certains d'entre nous, la jurisprudence de la Cour. J'observe la deuxième chose, et je vous le dis, Monsieur le Président, que ce rapport qui semble devoir être attaqué a été approuvé à l'unanimité à Belgrade le mois passé. Donc il n'est pas peut-être aussi mauvais que ça. J'entends l'argument que la Cour est militante, qu'il y aurait un gouvernement des juges. C'est vieux comme le monde, vieux comme le monde. Simplement, quand on regarde l'ensemble des arrêts de la Cour, y compris des arrêts les plus difficiles, on retrouve toujours l'élément de marge d'appréciation et un exercice de réflexion quant à la subsidiarité. Donc vous me permettrez d'être en parfait désaccord avec deux des trois interventions qui ont été faites. J'ai passé mon mandat de député, qui s'achève bientôt, à lutter dans mon pays, la France, contre une tentation de plus en plus croissante de ruiner la réputation de la Cour européenne des droits de l'homme, d'y ajouter parfois un élément de chantage visant à convaincre les juges, ce faisant, par une pression politique, de renoncer à des éléments de jurisprudence. Et je pense que ça n'est pas ainsi qu'on travaille avec une Cour de justice. C'est plutôt en essayant de comprendre ce que sont les éléments de raisonnement amenant les juges à certaines de ces décisions. Non pas que je suis en train de défendre 100% des décisions, mais je crois qu'une critique à charge violente contre la Cour ne rend service ni à la Cour, ni aux États, ni aux justiciables. Enfin, je m'exprime aussi comme quelqu'un qui a siégé pendant 3 ou 4 années dans la commission de sélection des juges à la Cour européenne des droits de l'homme, qui a pu remarquer l'ensemble des améliorations à apporter à notre processus. La Cour est finalement une aventure humaine avec ses succès et ses limites. Et je pense qu'il y a parfois un excès dans la critique de la Cour quand on ne s'attache pas non plus à comprendre comment elle est composée, comment elle est financée, comment elle est soutenue. On peut faire mieux ensemble. C'est ce que je voulais vous dire. Alors je vais vous poser une question, si vous admettez qu'on puisse poser une question. Dans mon rapport, dont je ne doute pas qu'il aura été lu, j'ai identifié de nombreuses violations liées à des problèmes systémiques ou structurels reconnus depuis des années, auxquels l'État concerné ou les États concernés n'ont pas pu, pour certains d'entre eux, ou pas voulu, pour d'autres, remédier. Et de telles situations, je pense à CEDH et Finci, par exemple en Bosnie, ont des effets très négatifs pour les États que ça concerne, mais sur le système conventionnel lui-même, y compris sur la Cour, y compris donc pour l'autorité de la Cour. Et je serais heureux d'entendre les solutions que vous proposeriez, chacun de vous 3 panélistes, sur cette difficulté, afin de pouvoir y apporter un remède au bénéfice de tout le monde et au bénéfice d'abord des requérants.
Merci. Ce n'est pas pour rien, Monsieur Le Borgne, que je vous ai donné la parole en premier lieu. Et je crois que vous n'étiez pas là au début, mais j'ai bien précisé que la continuation de ce séminaire serait l'invitation qui serait faite à la Cour la prochaine fois, sans contradicteur. Donc la Cour pourra venir s'expliquer une prochaine fois. Lord Balfe, vous avez la parole.
I don't think it does any harm for the court to be criticised from time to time, because there is a perception, let's say, that there's been a lot of what I would call mission creep. In other words, what's set out as a court of human rights has gradually expanded its powers and gone further and further and further. People made reference to the issue of prisoners in the United Kingdom voting. I'm not really sure that that is a central point that was devised in 1949 as being where human rights should be. And last week we had an instance in the United Kingdom where a High Court judge took a decision to allow a doctor to withdraw treatment for a baby that was definitely going to die and was terminally ill, and that was brought to the court in Strasbourg, as though, you know, there is no room anymore for a Supreme Court in a country. I just do not believe that that is an appropriate use of that court. And what does concern me is that if the court carries on in this way, it will end up losing support to a point where the good work it does will be swept away in a community anger against what is seen as being unreasonable interference. So my message to the court, which probably won't be listened to but is there nonetheless, is think carefully about what your core function is and try and do it, rather than constantly adding to those functions in such a way that can often alienate the population of the countries who are signatories to the Convention and part of the Court.
Thank you, Lord Balfour. Mr. Schwab.
Herr Vorsitzender, sehr geehrte Sachverständige, ich hatte eigentlich erwartet, dass wir eine etwas ausgewogenere Debatte hier bekommen und eine etwas, da können Sie nicht zu als Experten, sozusagen, das haben wir am Ende zu bestimmen, aber mein Eindruck war eigentlich, dass das anders beschlossen war, dass wir hier sozusagen Pro und Contra ein bisschen stärker diskutieren können. Nun ist es so, wie wir es jetzt hier haben und wir haben wirklich, so ist jedenfalls mein Eindruck, von zwei Experten einen Totalverriss gehört und deswegen glaube ich, war es gerade notwendig, dass wir einstimmig hier eben den Bericht von Pierre-Yves Le Borgne verabschiedet haben. Ich hatte erwartet, dass wir eigentlich mehr über Effizienzfragen reden, wie es ein bisschen beim dritten Experten auch entsprechend angeklungen ist. Jedenfalls sind wir dafür da, so glaube ich, verstehen wir uns hier, den Gerichtshof im Grunde jedenfalls, im Grundsatz zu unterstützen, indem wie er dort entsprechend agiert. Ich habe es in der Tat nicht ganz verstanden, wie Sie argumentieren. Ich will zwei Punkte ansprechen. Das eine ist, ich komme aus Deutschland und in Deutschland war zum Beispiel im Jahre 1950 Homosexualität strafbar. Nehmen wir mal an, wir hätten uns nicht weiterentwickelt in der Zwischenzeit, dann wären wir da wahrscheinlich entsprechend stehen geblieben. Wir werden jetzt in dieser Woche wahrscheinlich die Ehe für alle noch im Deutschen Bundestag beschließen. Das heißt, da ist ja wahnsinnig viel passiert in der Zwischenzeit. Würden Sie wirklich erwarten, dass der Gerichtshof das sozusagen überhaupt gar nicht zur Kenntnis nimmt, sondern eigentlich auch sozusagen einem Rechtskonstrukt, Gegebenheiten von 1950 entsprechend agiert? Und ähnlich ist es bei der Frage der informellen Selbstbestimmung, also bei der Frage, wie gehen wir eigentlich mit neuen Medien um? Sowas wie Twitter oder sowas gab es nicht. Das heißt, es gab auch keine Journalisten, die das nutzen konnten und keine Journalisten, die sozusagen aufgrund der Nutzung solcher Einrichtungen ins Gefängnis gebracht worden sind. Also insofern gibt es doch gar keine andere Chance, als sich sozusagen kontinuierlich auch anzupassen an veränderte gesellschaftliche Rahmenbedingungen innerhalb der Mitgliedstaaten des Europarates. Oder was wäre Ihre Empfehlung eigentlich? Was wäre die Alternative? Würden Sie sagen, nein, da muss zunächst mal eine neue Menschenrechtskonvention her? Oder wie machen wir das? Machen wir das alle 3 Jahre, alle 5 Jahre, alle 10 Jahre? Also wie würden Sie sich das vorstellen? Und wirklich, geben Sie doch mal bitte eine Antwort darauf, wie man eigentlich den Gerichtshof effizienter in seiner Ausgestaltung machen kann. Das finde ich eigentlich eine spannende Frage. Und ich denke, das ist auch vor allem der Titel entsprechend der Veranstaltung, so wie ich sie verstehe.
Merci. Lord Anderson.
Chairman, 2 points. First, I think that the presentations were of such interest that I would like the time to read them quietly. And I hope it will be possible, perhaps, for our contributors to furnish to us, and perhaps the committee can actually put them together in written form. Secondly, I was struck by this, that I personally think that we should follow the judgments of the court, even if we disagree with them. But certain judgments have left me at least with an understanding of the criticisms made by the court in the right-wing press in our country as being out of touch. The criticisms, for example, sometimes of the competence of the judges compared with the competence of the judges, yes, in Germany, yes, in the Netherlands, less in France, UK, and so on. And the fact that the court sometimes gets the balance wrong, that in my country, understandably after the recent terrorist outrages, there is a great concern that as a result in part of judicial decisions, there are 40 terrorists, foreign terrorists, in our country whom we can't deport, in part because a great balance given to the family considerations of splitting up families. Now, justice for me cries against that decision. It's an unwillingness to listen to the good sense of people. And judges are not sort of on Mount Olympus beyond criticism. And so at least I think that, as a number of the speakers have said, there is a case for a certain restraint, even though my own view even on the Hearst case, where I think that the franchise is essentially something within the competence of national legislatures, unless it is so beyond the bounds of anything reasonable that one can intervene. I think that there is at least something to make judges sit up and take notice, even though since my country has signed the convention, I feel bound, if only because giving a bad example to others, that we must follow the judgments of the court.
Thank you very much, Mr. Lopinski.
Thank you very much, Mr. President. First of all, I would like to thank our rapporteur for a very important report. And my name is Georgi Lagvinsky. I am Vice President of the place on behalf of Ukraine. And this is why I just want to ask you questions about the role of court in relationship to international conflicts. So in this case, my country, Ukraine, has been invaded by our neighbor of North. Georgia has suffered the same fate. Both countries have brought the interstate cases before the court. We see the cases as a very important tool of international justice. We hope that it will lead to the withdrawal of occupied forces and the payment for compensation for the thousands of victims of violation, for the families, for the people who have been killed or disappeared. However, we are still waiting for the court to give us judgments on these cases. In the meantime, the court under the Article 39 has ordered interim measures against the respondent state in an attempt to avoid future conflict and loss of life. Unfortunately, they have not had the proper effort, but we are glad that court did this. It's very important for us. I would like to ask the speakers, what else do you think the court should do in these cases? Should the court be given greater power? How should the Committee of Ministers act in case the court's judgments are in favor of the occupied countries? Thank you.
Thank you very much. I'm going to close the list of speakers. I still have Madame Bezelia and Madame Brasseur. If somebody else wants to speak, it is now. Madame Bezelia.
Thank you, Mr. Chair. First of all, I would like to express my gratitude. Very interesting presentation, very interesting comments. It's very important issues for our committee, especially. I'm interested in your opinion, your comments about the Protocol 15 and 16. My country, Georgia, has ratified this protocol last year. What do you think about the cooperation between European Courts Human Rights and the national courts level? What's your opinion about it? Thank you.
Thank you, Madame Brasseur.
Well, I had also a question on Protocol 16, and first of all, on the judicial dialogue, which was promoted by my compatriot Dean Spielman, the former president of the court. And this allows national courts to come to Strasbourg, and also judges of the Strasbourg court visited national courts in order to have an exchange. And Yves Le Bon referred to it, that it is important to understand. So I want to ask our panelists whether you took advantage of this possibility to come and to have contacts with the Strasbourg court. So that's the first question. And the other question is related to Protocol 16, where the national courts can ask a non-binding, put a non-binding question to the Strasbourg court about the interpretation of the convention. So what expectations do our panelists have from this Protocol 16? So thank you very much.
Yes, to start with the last question, especially the opinion under protocol number 16, looking at the same possibility in the European Union court procedure. I think it is very helpful, as in cases especially if a new area of law is coming up and the court does not know what to do, it might be helpful. But I think there will not be much cases coming up, but that's my personal view, because, it is the duty for the courts, at least in Germany, to not to infringe in the convention anyway. So they might think they get it right, and they don't have to get the answer beforehand from the court. And I think the different and advantage of the European Court of Human Rights against the European Court of Justice in Luxembourg is that it is up to parties to go to Strasbourg and claim the infringement, and that it's not for the court to ask an answer beforehand. It is a court for the people to go there and claim their rights, and I don't think that will change very much, although in some critical areas it might be helpful to have this possibility. Otherwise, and this is the question Mr. Schwab put about the efficiency of the court, well, it's so popular, I just don't know what to do. And if you have the possibility to go to the court without a threshold, without anything, you can't stop people to go there. And I think it's the question will always be to find out for the court and for their rapporteurs the case is worth being handled by the court itself, and the other case is just being put on an administrative agenda and being kicked out on this way. But my fantasy is not going wide enough to think otherwise. It is perhaps the black side of its success and its jurisprudence, and to come to this, and I think the cooperation with constitutional courts, with national courts, is very, very important to understand the thinking of the national jurisprudence of the national constitutional courts. And in Germany, we have a very strong and powerful constitutional court, and this court has to settle with the jurisprudence of the European courts in Strasbourg and Luxembourg, which sometimes is not easy, and which sometimes is not easy for ordinary judges to get through all these decisions we have in the same area from sometimes 3 different courts, but it's absolutely essential. And my impression is that it's getting better, and in the future the clashes between the constitutional courts will be less. And therefore I don't think that Strasbourg and the jurisprudence of Strasbourg does not leave any room for other high and supreme courts. It does, and it is absolutely necessary that it does, because that's the idea of Article 35 and Article 13, that you have to get to an independent and well-functioning national Supreme Court first, and then it is up to Strasbourg to do the supervision. So I think strengthening the national jurisprudence is perhaps one way of reducing the caseload. Also, I'm a bit pessimistic about the success of it.
Thank you very much, Christoph.
Thank you. I would like to address some of the points raised by those who took part in this debate, but please remind me if I would omit anyone who raised important issues addressed more or less to me. Firstly, the question was raised by Mr. Schwab, I understand. There is certain misunderstanding in your perception of my submissions here, because if in your example that in your country there was a punishment for homosexual practices, of course it's very good turn that these or other developments simply prohibited that sort of behavior conduct by state. What I meant was that in those questions concerning private family life, the court should not try to impose certain views on protection of values which domestically are at some stage of social consensus. That's a protection of life. Yeah? And if suddenly in a case we get response, you must go further to some direction, this disturbs, it's not a question, for us it's judgment, we will have to change law probably. But if this touches certain consensus in the society, very light balance, very sensitive, so this is another thing. So what we mean here is that basic values for human beings are protected through minimum human rights standards here. And our great appeal to the court is not to do it as a sort of imposition on other countries. We may go to further examples. Article 18, which I mentioned, of the Polish Constitution, does not at this situation, at this legal state, allow us to accept different sexes marriages. Yeah? But it is nothing against protection of these different partnership by all possible law, be it civil law, registration law, succession law, etc. Just only this should not be a fully fledged couple in terms of marriage. So this is here dialogue necessary, that the court will understand that we ask for more respect for our views of our population, of our voters, than being imposed. We are probably so sensitive after communist time when so many things were imposed on us and against values of the society. I understand you said that asking what would be in place, what I would propose in place. No, nothing in terms of new convention, new mechanism. No. We have excellent list of rights. We have excellent court, but should it go too far in interfering with the basic values of societies, there should be certain clear second thought thinking by the court, a reflection where are its limits, like in the case of terminally ill child. Exactly, this is a good point. Lord Anderson raised the question of for instance, criticism of competence of judges. I was a member of the DHPR committee, droit de l'homme procedure, for years, and we have gone through protocol number 11 and subsequent changes to the system of election. We know that Parliamentary Assembly is working a lot on its rules, which change through years. And what I would say that in our European interest is, without me pointing to this or another judge, to have judges as much experienced in judicial work as possible. Look, this is an interesting point. Some of the international treaties, having a sort of lack of confidence in some states, probably, start to regulate on issue of election. Let's say, take Rome Statute of International Court of Criminal Court. They say how many specialists of human rights and humanitarian law should be. How many specialists of criminal law and criminal procedure. Why? They did not want human rights group to become in dominant position. They wanted to have a good mixture of criminal lawyers and criminal substantive and procedural law and those of human rights and humanitarian law, which are quite different branches of law. So your experience would be very, so to say, one-sided if you become a judge. they interfered in this by providing for such formulation in law, in the very statute. I have been always, it was something to guess, why we have this sophisticated, in the Council of Europe, system since 1949, how to elect judges. A long procedure, parliamentary assembly, hearing, it's good. Still 1 minute. But people maliciously often say that Luxembourg has judges of the same or even better quality, professional qualities. And they don't have the system, just governments come and propose. That's interesting. So that's something for, I know that the committee, your committee works on these rules, and good luck if we achieve this.
If you can stop, because in 5 minutes we have to stop and we have to give the floor to Mr. Bossait also. So let's give the floor to Mr. Bossait, and if we have some time, I'll give you the floor again.
Because I thought about the questions which I was... yeah, okay. Thank you.
We have to stop in 5 minutes exactly, because there is the plenary. So.
Merci, Monsieur le Président. Je vais m'exprimer en français. Tout d'abord, en ce qui concerne la demande de pouvoir disposer du texte de mon exposé, il existe, il sera disponible, il peut être distribué. Donc, et je pense que ce sera utile parce que vous trouverez dedans également les références qui contiennent d'autres arguments, parce que c'est totalement impossible dans un laps de temps de 10 minutes d'exposer avec toutes les nuances voulues les positions qu'on souhaite exposer. En ce qui concerne l'exécution des arrêts de la Cour, moi je n'ai pas de critique à formuler à cet égard et je suis un partisan de l'exécution des arrêts de la Cour. Ce n'est pas parce que je critique des arrêts que les arrêts ne doivent pas être exécutés. On est plus dans un état de droit si les arrêts ne sont plus exécutés. Mais ce n'est pas parce que les arrêts sont juridiquement obligatoires et qui doivent être exécutés qu'on n'aurait pas le droit de les critiquer d'un point de vue académique. Ça ne devrait pas être un tabou, ça ne devrait pas être un sacrilège de critiquer les arrêts de la Cour. Et pourquoi je pense que c'est même nécessaire? Parce que je constate quand même qu'il y a, au fil des années, une évolution de la jurisprudence de la Cour qui va toujours plus loin, plus loin, plus loin. On ne sait pas où ça va s'arrêter et je dois vous confesser que je suis particulièrement inquiet si j'imagine ce que la Cour dira dans 25 ans par rapport à ce qu'elle a fait il y a 25 ans. Donc l'évolution est vraiment considérable et on voit que des arrêts anciens qui étaient universellement acceptés sont renversés par la Cour, parce que ce qui m'a frappé, et vous allez le voir dans mon texte, que pratiquement tous les arrêts que je cite sont des arrêts qui ont renversé une position antérieure de la Cour, peut-être plusieurs années avant, ou simplement la Chambre un an avant et puis la Grande Chambre prend un autre point de vue. C'est généralement le cas. Donc il y avait des juges qui avaient une autre position et cette position me paraissait défendable lorsque cette position a été adoptée. Elle me paraît toujours défendable de ce jour-là et on ne devrait pas être accusé de miner l'autorité de la Cour parce qu'on soutient une position qui a été défendue antérieurement. En ce qui concerne vraiment, c'est ça la grande question, quelles sont les limites de la jurisprudence, quelles sont les limites du champ d'application de la Convention, quelles sont les limites de la juridiction de la Cour. Et dire qu'il n'y en a pas et que c'est à la Cour de décider au cas pour cas jusqu'où on progresse chaque année un pas de plus, ça ne m'apparaît pas une position juridiquement défendable. En ce qui concerne le protocole et qui prévoit la possibilité de demander des avis consultatifs à la Cour, je dois vous avouer que je n'étais pas un partisan. D'ailleurs, le ministre de la Justice à l'époque a demandé l'opinion des trois cours suprêmes de Belgique, le Conseil d'État, la Cour de cassation et la Cour constitutionnelle, et nous avons unanimement donné l'avis qu'on pensait que ce n'était pas une bonne idée. Pourquoi ce n'est pas une bonne idée? Tout d'abord, je pense que c'est contraire au principe de la subsidiarité, parce que le principe de subsidiarité présuppose tout au moins que les tribunaux internes prennent position d'abord. Et ce n'est qu'après que les tribunaux et les cours de droit interne ont pris position, qu'on peut soumettre ça au contrôle de la Cour européenne des droits de l'homme et non pas l'inverse, que d'abord on ne sait pas quoi faire ou on n'ose pas faire ce qu'on pense devoir faire et on va demander l'avis à la Cour et puis on va faire ce que la Cour conseille de faire. Je dis conseille de faire parce qu'on dit que ce n'est pas obligatoire. Alors quelle est l'idée d'avoir un avis consultatif à demander à une Cour et puis après, si le tribunal de droit interne ne suit pas cet avis, qui aura le mot? Celui qui a donné l'avis. C'est un peu, pour les luxembourgeois, procola, c'est un peu une confusion des genres qui me paraît pas indiquée. Je pense que ce protocole voulait répondre à des critiques qui sont faites à la Cour, mais je ne pense pas que c'est une manière d'y répondre d'une manière constructive et positive. Voilà l'essentiel de ce que vous voulez dire, Monsieur le Président.
Merci. Professeur, je peux vous donner encore la parole 2 minutes, si vous n'avez pas fini.
Avec plaisir. Just to follow questions which I think were addressed to me. As far as question of Mr. Longwiński is concerned,
Yes.
it's quite difficult to answer your question, particularly that we have to do with 2 or 3 possible procedures. In my view, sorry for expressing this so bluntly, this is a case of coming back to fundamental question whether this country, which invaded yours, follows admission criteria. If not, there should be a study on Article 8 of the statute, whether it still continues to conform to these principles. Simply, this is a question of membership. Plus, as you see, there is a non-execution of many judgments to a scale which is, in fact, challenging the court. I, however, think that diplomatically, for parliamentary diplomacy and for governmental diplomacy, it's better to try to find ways for Russia. But it is, in fact, for the Council of Europe, a question of fundamental rule. Let us not forget what happened with after Greek colonels' coup d'etat and how cautiously, if not cowardly, the Council of Europe bodies behaved on that time. So it took 2 years, and in fact, the European Commission prepared a good report, and Committee of Ministers was ready to expel Greece. However, Greece did it itself. So this is not a good example. And finally, question of the dialogue, both that the dialogue is here absolutely necessary. However, I think that the next discussion like this should also focus on reasons of the negative opinion of the Luxembourg court, because I'm afraid that there are not only legal elements in this, but also, certain rumors talk about it, to what extent the assessment of the unstable jurisprudence of the Strasbourg court made Luxembourg court.
Thank you. Colleagues, please join me to thank our 3 panelists. Thank you. So shall I consider that I have the authorization of the committee to invite the European Court of Human Rights for next session in October? No objection. Thank you very much.